Today we'll be discussing the morbid yet important specifics of how to administer the estate of a missing person in California, what steps you have to take, and how long can someone be missing before they can be considered legally deceased. My name is Andrew. Hit the like button and let's dive in. As with any topic like this, we first need to review the actual text of the law itself before we can get into putting it into practice. In the case of a missing person, we need to look at California Probate Code Sections 12,400 through 12,404. These provisions address the presumption of death for missing persons and guide the administration process of their estate. In California, if a person is missing and their whereabouts are unknown for a continuous period of 5 years, they are presumed to have passed away. This presumption provides a basis for initiating the probate process and getting a death certificate. That means that nothing can be done on the estate for at least 5 years. Broadly speaking, the steps for getting a death certificate and administering one's estate is a 3-step process. Step 1, gather evidence. If a missing person's absence has reached the 5-year mark, it's crucial to gather relevant evidence. This evidence can include newspaper articles, police reports, court reports, or any other documentation supporting the presumption of death. Step 2, file a petition with the probate court. To initiate the process of acquiring a death certificate and thus declaring someone legally deceased, you would need to file a petition with the probate court. This would typically be done in the county where the missing person resided or where their estate is located. Now that petition would include the gathered evidence and a request for the court to declare the missing person as deceased. Step 3, court review and determination. The probate court will review the evidence provided in that petition. It'll consider the circumstances surrounding the person's disappearance and decide based on the California Probate Code. If the court is satisfied with the evidence presented, it may issue a court order declaring the missing person as deceased. Now, once you have that court order, you can use it to apply for a death certificate from the California Department of Public Health. Now that you have a court order and death certificate in hand, you can proceed to administer that person's estate as you would any other's estate. If they had an estate large enough to warrant opening a formal probate, then upon the court's order declaring them as deceased, then you would go on to petition the court to then probate their estate. But if the deceased person's estate does not require a probate or a court involvement, then you would take that death certificate to any banks and close down those accounts and just administer the estate from there. The primary hurdle in this situation is, of course, the 5-year waiting period, during which very little can be done to administer the person's estate. This is especially complicated when there is real property involved, so if the family intends on keeping the property, then they'll need to make sure that it's well taken care of and isn't foreclosed on if there was a mortgage on the property. Now, if you want to deep dive into how to administer someone's estate in California, then you can check out our video on how to settle an estate in California. Or you can check out our video from last week. Be sure to hit that subscribe button and ring the bell on your way out, and I'll see you next time.